the factors to get a divorce or a dissolution in the county and the state of California. So, Mark, what do you know about this?
Well, on this particular case, I think when it started getting more interesting, Kincaid's ex-wife or soon-to-be ex-wife painted his girlfriend, painted like painter, so as a greedy and money-hungry, and simply wanted to bleed the man's estate dry, and that the ex-wife claimed that the girlfriend was jeopardizing the claims of the rightful heirs, and so that would be her stance. But she kind of painted a bad
okay, well, let's
character.
talk about that, how that it really applies in California. California is a community property state, and it's also a no-fault divorce. And this no-fault divorce system is a way that people can get a divorce without having to prove somebody's evil. So what just happened in that last case we were talking about, we moved into what a divorce really is, because this was a good lead-in. In a community property state like we have in California, that's no fault. It is, you get married, you have your earnings for both parties or one party, and what happens is, technically speaking, for the length of the marriage, if it goes beyond 10 years, it's known as a long-term marriage, and that means your spousal support and things like that go on a long time. Now, starting a dissolution is very easy. You file a petition, you file a declaration if there's children involved, you file the income and expense showing what your income and expense is, and then the respondent, whether that be the husband or the wife, has to file a response, and they have to file their income and expense. And at that point, once that's in place, what happens is now the courts are still staying out of it until you really start arguing about what are the assets. Now, the Kincaid estate had large assets, but the average estate normally has, in the Bay Area it's a little different, but the average estate usually has less than $1 million in total. And so what happens is there's a problem. If a husband or a wife decides they're the earners in the family and they decide they just want to divorce their spouse, they can file a petition, they serve the other person, and they can do what they wish. But the courts aren't going to let them do that, because normally the opposing spouse is going to say, wait a minute, you're making all the money. How am I supposed to live? And if there's been a marriage of long-term duration, that's over 10 years, you can effectively be responsible for paying your non-income earning spouse for life for spousal support, let alone paying for the children. All children under the age of 18, you're going to have to pay for them. And then there's a whole custody question. So divorce is a really very complicated matter. And what you're looking at the Kincaid matter it's complicated only because there's so much money. Right. It's not so complicated that their kids were they had 4 children, they're all adults, so they're over 18, but the wife was still married. That was Kincaid's problem, that he was still married, because that still gave her a right to even argue.
Right.
And so in most divorces, what happens is, if it's a no-fault divorce, you can easily do a divorce if they're cooperating.
Right.
Not arguing over money. If they're cooperating, they can do a divorce in 6 months and 1 day.
Right.
But that's extremely rare, because what happens is parties don't cooperate. So when you look at something like the Kincaid matter, you go, well, wait a minute, the cooperation's all about the money. That's where the cooperation
Well, they got some cooperation in this particular case, in the Kincaid case, even though we're kind of going back into the estate.
But they mix a little bit.
But was that if Kincaid, or Thomas Kincaid, got a bad reputation for having the squabble between his girlfriend and his wife, that would affect the value of the paintings. So the collection would go down. So they wanted to do everything confidentially so that it wouldn't affect the price. And so that sometimes brings people together.
Well, in this county, in Santa Clara County, I should say, and a lot of the counties, I should say, in California, you can hire private judges. So you can actually keep everything off the public record. Right. For settlements like this. And they have something called settlement officer conferences, which kind of sets that up. And then you hire a private judge, and the private judge is the only one that really starts listening to all the dirty details. Right. If there's a high income wage earners. There's cases where I've had where both parties were making over $1 million a year, and that's not counting their stock and all that. But what happens is, if that goes out in the public and you start saying, well, so and so makes 100 whatever amount, that becomes a public record. So many times you try to keep that quiet. In this case, the Kincaid case, this is why it goes along. They wanted to keep that quiet because they didn't want to disparage his background.
Well, there was something in an arbitration clause in some of the
A
paperwork.
binding arbitration.
But the judge said, no, 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 this is going to have to go to court. We're not going to go through arbitration. So at that point, they were they're saying, well, wait a minute, we thought we had a mechanism for keeping this all quiet. The judge says, no, we wanted this to be an open court. And so they quickly went to settle.
Funny you could say that, because right after the judge said, oh, no, we're going to put it in open court, within 2 months,
right, they figured something out.
Totally settled it privately with no release of the confidentiality terms of that settlement, which I find a smart thing to do.
And another thing that was kind of interesting about that case is, going back to the will, the second will was signed, wasn't there a great amount of time between that and the time he died. So I think that maybe hurt the girl's case a little bit, because there's always suspect. What do you mean? This guy took some pills and drank too much and died. So that kind of makes it look a little funny.
It was kind of coincidental.
It was like 2 months later.
Yeah,
or 2
it was
months
like a
later.
couple of months later after he signed the second holographic.
But a lot of times,
codicil.
like a trust or a will, or even a grantee is signed like several days before death, and that's always looked at a little bit suspect, even though someone could have capacity right before death, but it still makes it look a little askance.
Well, what's interesting about that will idea, a will normally needs 2 witnesses.
Right.
And you have the people watching have to be there and watch the signing. And in a trust, you need a notary. So anyway, I'll just finish up on this family law issue. Family law is it's very complex. So if anyone out there is thinking about getting a dissolution or a separation, you got to be really aware of what the circumstances will be once you enter that process. Now, the judges will not help you. They will mediate sometimes in court, but most of the time you're going to have to understand there's just going to be a high financial cost, but you want to make sure that you follow through.